For today's story, we're talking about the case of Stephen Thaler versus the USPTO. Stephen Thaler is a guy who really believes in artificial intelligence, and he believes in it to the degree that he has asked both the Copyright Office and the Patent Office for the ability for machines to get both copyright and patent protection, respectively. Now, both offices have told him no. The Copyright Office has told him no. I don't believe that case has yet gone to court. Last I read of it, that case was still percolating. The last I heard of it was the final decision from the Copyright Office. So I assume he's filed a lawsuit on that. But there was an earlier decision from the same guy from the Patent Office where he was told no, and that case has gone to court and, in fact, has resolved in a decision from the Court of Appeals for the Federal Circuit. So let's go ahead and get started with this. Thaler represents that he develops and runs AI systems that generate patentable inventions. One such system is his device for autonomous bootstrapping of unified science. I don't know what that means, which Thaler calls DABUS. Thaler has described DABUS as a collection of source code or programming and software. Okay. When he filed his application in lieu of an inventor's last name, Thaler wrote on the application that the invention was generated by artificial intelligence. To satisfy the requirement that the inventor submit a sworn oath or declaration, which is a requirement, Thaler submitted a statement on the machine's behalf. Secondly, Thaler submitted a supplemental statement of inventorship explaining that DABUS was a particular type of connectionist artificial intelligence called a creative machine. The Patent and Trademark Office said not so much and said, we're not going to process your application at all because you don't have one of the requirements of the application. Namely, you don't have the signed statement from the inventor, so we're not even going to look at your application. Thaler sought reconsideration, of course, which the PTO denied. Thaler then pursued judicial review of the PTO's final decision under the Administrative Procedures Act. After briefing and oral argument, the district court granted the Patent Office's motion for summary judgment and denied Thaler's request to reinstate his applications. The district court says no. The district court concluded that an inventor under the Patent Act must be an individual and that the plain meaning of individual as used in the statute is that of a natural person. The sole issue on appeal, therefore, is whether an AI software system can be an inventor under the Patent Act. And, by way of collateral comparison, also whether or not they can be an author under the Copyright Act. In resolving disputes of statutory interpretation, we begin with the statutory text and end if that is unambiguous. Pretty standard stuff. Here, there is no ambiguity. The Patent Act requires inventors must be natural persons, that is, human beings. So, under U.S. law, in order to have a copyright or a patent, you must have a human inventor or human inventors. Now, the human inventors can use the assistance of AI tools, right? So if the human inventor is using an AI to help generate things and then the AI and then the human produces things on top of that, you can have a copyright that way or a patent that way. So like, for example, if you use some sort of machine learning to develop an idea and then it inspired a human being to then, create a product, that would be fine, right? Because a human being is in the loop. What we're trying to deal with here is where there's no human being in the loop. Basically, all the human being is doing, if anything, is providing basically a prompt. That's not enough, right? That's not enough because that's just instructions. Instructions by themselves are not copyrightable or patentable, right? You need something more. So here, the office says, no, your machine is basically doing everything autonomously. There's no human being in the loop. If they ever were in the loop, they're so far removed from the loop that the machine is the one that's creating. According to you, incidentally, you're the one saying the machine is creating, by the way. It's not even a determination that we made. You made the determination. So yeah, no, not so much. The Patent Act expressly provides that inventors are individuals. The Patent Act does not define the term individual. No one thought we would have to. But what do you think it means? However, as the Supreme Court has explained, when using a noun, individual ordinarily means a human being, a person. This is in accord with how we use the word every day. We say an individual went to the store. The individual left the room. The individual took the car, unmistakably referring to a natural person. So thus also does the Dictionary Act, which is an act of Congress, which provides that legislative use of the word person and whoever broadly includes corporations, companies, associations, firms, partnerships, societies, and joint stock companies, as well as individuals. So when you're talking about when you have the word person, it can include these corporate entities, but even corporate entities are composed of people. With the phrase as well as, the definition marks individual, as distinct from the list of artificial entities that precedes it. Yeah, an individual is not of any of those things. That's true. Showing that Congress understands individual to indicate natural person unless otherwise noted. Thaler directs us to several provisions of the Patent Act as supposed support for his position that inventor should be broadly read to include AI software, but each fails to persuade. First, Thaler points to use of whoever in Section 101 and 271. Section 101 provides that whoever invents or discovers any new or useful process, machine, manufacture, composition, matter, or any new and useful improvement thereof may obtain a patent thereof, subject to claims of this title. As the section makes very clear, however, patents must satisfy the conditions and requirements of the title, including the definition of inventor. Section 271, in setting out what constitutes infringement, repeatedly uses the term whoever, which includes corporations and non-human entities, as we defined earlier from the Dictionary Act. That non-humans may infringe patents does not tell us anything about whether non-humans may also be inventors of patents. The question before us inevitably leads us back to the Patents Act's definition of inventor, which uses the word individual and not whoever. Second, Thaler contends that AI software programs must qualify as inventors because otherwise patentability would depend upon the manner in which the invention was made, in contravention of Section 103, which deals with what obviousness is, right? So what do you need to have in order to get an invention, right? So under Section 101, it has to be useful. And then under Section 102, it either has to be novel or Section 103, non-obvious, right? So novel, which is pretty hard, incidentally, because most things have been done before, but occasionally it does pop up, or non-obvious, right? It's a collection of things, but the collection thing is non-obvious. So Section 103 says, okay, yeah, it has a section dealing with non-disparagement of the method of creation. But as the court notes, Section 103 is not about inventorship. It instead provides in relevant part that inventions may still be non-obvious, even if they're discovered during routine testing or experimentation. And then the courts have noted that the second sentence of 103 was intended to clarify that a flash of creative genius is unnecessary for patentability. The statutory provision relates to how the invention is made and does not trump as to who may be the inventor. So yes, under Section 103, like, we do not disparage the method of the invention. Basically, the concept of sweat of the brow in patent law and in copyright law is dead, right? We don't care under the copyright law or the patent law how easy or how hard it was for you to come up with your idea. Some ideas are really, really hard, take a lot of time, a lot of effort, and sometimes ideas are really, really easy and come in a moment, in an instant. Either way, it doesn't really matter, right? It doesn't also require there to be a particular flash of creative genius. If you come upon an idea and it's like, oh, okay, well, there's a thing, great, right? We don't care. But still, it's you that comes up with a thing. That's the part where we care about. So how Section 103 would be relevant is if you used a computer as part of the creation of ideas, right? If you used an AI machine to come up with different ideas that would serve as inspiration, and then a human being based on that inspiration then went and created the thing, finalized the thing, then sure, then you have a human acting as an inventor. But, the computer can't act alone. And no. Statutes are often open to multiple reasonable readings. Not so here. This is a case in which the question of statutory interpretation begins and ends with the plain language of the statute. Yep. In the Patent Act, individuals, and thus inventors, are unambiguously natural persons. Accordingly, we have no need to consider additional tools of statutory construction. Well, Thaler, of course, is by no means himself done in his arguments because he's going to keep trying to make different arguments work. So despite the fact the statute is super, super clear, he's going to try some other stupid things. So let's try the other stupid things and see if it does any better. Thaler argues that inventions generated by AI should be patentable in order to encourage innovation and public disclosure. Thaler's policy arguments are speculative and lack any basis in the record. In any event, the text before us is unambiguous, and we may not elevate vague invocations of statutory purpose over specific words. Thaler invokes the canon of constitutional avoidance. In Thaler's view, permitting AI programs to be inventors would support the constitutional purpose of patents to promote the progress of science and the useful arts. Yes, but it has to be to the inventors and authors. It's in the Constitution. So it's not even clear, incidentally, that Thaler's proposal is unconstitutional. It follows, Thaler continues, that not recognizing AI as an inventor undermines progress, raising potential constitutional concerns. The constitutional provision he cites is a grant of legislative power to Congress. Congress has chosen to enact pursuant to the power by passing the Patent Act. Thaler does not and cannot argue that limiting inventorship to human beings is unconstitutional. That would be pretty hard, seeing as human beings were definitely the thing that were in mind. In fact, giving inventorship to machines may not be constitutional. The argument the other way around may be the unconstitutional one, because when the Constitution says authors and inventors, probably had human beings in mind. Thaler additionally notes that South Africa apparently has granted a patent with DABUS as the inventor. So South Africa apparently believes in the AI machine overlords. Okay. This foreign patent offices, of course, was not interpreting our Patent Act. Yes, you have a South African patent, apparently. This has little to do with whether or not you have a U.S. patent. So its determination does not alter our conclusion. No, South Africa is, in fact, a different country with different laws. So their determination, while interesting and all, not so much. Thus, that brings us to the end of this case dealing with Stephen Thaler, who has a serious bug up his ass when it comes to AI, because both before the Copyright and the Patent Office has tried to make these arguments. Now, the Court of Appeals for the Federal Circuit has slammed him down. He said he's going to appeal. There is no chance on this earth the United States Supreme Court is taking this case. And the Copyright Office has reached its judgment. I don't believe the courts have yet spoken to that, but it has been well understood for a very long time that copyright law and patent law are very informative of each other. And it is often the case that decisions in patent law read on decisions in copyright law and vice versa. Plus, of course, the copyright law has basically the same provisions in play. So the courts may not have reached this decision yet in the copyright law, but they will inevitably, based on this and other decisions. But until that time comes, that leads us to the end of discussion of this story.